number 46, the people of the state of New York versus Dashawn Deverow. Good afternoon, counsel.
Good afternoon, Your Honor. Alice Kalina on behalf of Dashawn Deverow. I'd like to request to reserve 2 minutes for rebuttal.
2 minutes?
Yes.
You may.
Thank you. Mr. Deverow stands convicted of murder after a trial that was decidedly skewed in the people's advantage, given the court's preclusion of the near entirety of the defense evidence and its unfavorable and unfair Sandoval ruling. To start, I would turn first to Ms. Johnson's testimony that was entirely precluded. Mr. Moten was the only eyewitness to the shooting, and he was the only person to say that the shooting was unprovoked, which was the key to the people's case against the justification defense that my client raised. And Ms. Johnson's testimony would have been direct evidence that he was either lying or mistaken about what he was doing immediately prior to the shooting, seconds before he encountered who he said were the shooters, and that would have made it circumstantial evidence that he was either lying or mistaken about what he saw in those seconds right after he was supposedly...
So your argument is that her testimony goes to the heart of the issue at hand, not simply something that which was collateral?
Yes, absolutely. I could envision a case where an eyewitness was on a bus and saw a domestic dispute and said he was on the bus because he was going to work, and if the defense proffered evidence that he was actually on the bus because he was going to get a nose job, that would be collateral, but that wasn't the case here. This was why he was on scene in a case that had a lot of unanswered questions, generally and specifically about his testimony. He claimed that he saw a party and socializing, but in the 2 minutes before the shooting, what the video showed was 11 men walk determinedly, march out of the building all together and walk right in front of where the camera could no longer see them, and that was right before the shooting. It certainly was not socializing.
Just to explore that a little bit, is it possible that he could have just been mistaken about the night that he was out with Miss Johnson?
I think even if that was the case, that would put a lot of concern about his testimony because, I mean, he testified very specifically that he heard 2 shots and then 11 shots, that he saw my client and his co-defendant raise their guns, turned around, didn't see them shoot, but somehow he knew that they fired first. And if he didn't remember who he was with right before that, and also I would say that what the defense proffered that her testimony would have been, she didn't have a chance to put this before the court because the court wouldn't even do an evidentiary hearing, but the defense proffered that she would have said she didn't even live there, and he said the reason they were there was he was walking her home. So even if it was a different night, that wouldn't explain that discrepancy.
And here it matters because he's the only one that identified your client as the one shooting first.
Exactly.
Did the defendant argue that he had been at trial, that he had been misidentified by the sole witness, or was his defense limited to a justification defense?
The primary defense was a justification defense, but they did also argue that the people didn't carry their burden to prove that he had the intent to shoot. There wasn't a true misidentification defense because Mr. Moten said that he knew the...
So is that relevant to our analysis as to whether or not he was deprived of his right to a fair trial by the preclusion of that witness?
Absolutely not, given that there was a justification defense raised. The people have to disprove that beyond a reasonable doubt, and this evidence would have been crucial to that they wouldn't have been able to, or it would have been much harder for them to if this evidence was there. The jury would have had much more before it to doubt that they had disproved his justification defense. And it also goes in connection with all of the other evidentiary rulings. So I would turn to the 911 calls, and most crucially, Ms. Molina's 911 call. This court instituted the corroboration rule for present sense impressions in Brown because it was concerned about defendants having evidence come in against them that was not tested by cross-examination. Those concerns are clearly not at issue here. Ms. Molina did testify, and both parties could have brought out why there were inconsistencies, as they did to some extent, between her phone call and her testimony at trial. But to say that the phone call couldn't come in at all because she said one thing that was inconsistent between the call and her testimony does not render it an uncorroborated present sense impression. And this court has made very clear that 911 calls are particularly powerful and probative. And I do want to make clear that although the appellate division first found that this call would not have been relevant, that's clearly incorrect, and the people don't defend that now.
Counsel, I'm on the screen, but this question about the 911 calls are powerful and usually admitted, isn't that when you don't have the caller? Isn't that possibly enough of a difference here that we can't say the court erred in making this determination?
That's not the crucial difference. There were several cases, and I'm blanking on which case it was at this moment, but that found even though the complainant testified, their call was still powerfully probative and contrasted recollective testimony against the testimony.
Even when the witness admits that there is a discrepancy?
Not in that case, but I don't think that takes away from the power. And in this specific case, it doesn't, because what ended up being elicited was that she had said she thought the shooters were in the car and that she had said there were people in the car. But what she actually said was unprompted. The 911 operator didn't ask her about this. She unprompted said the shooters were in the car. Again, after the 911 operator said help is on the way, she unprompted said, and tell them the shooters were in the car.
What more would the jury get from hearing this?
She sounds really very certain, and when I think most important, at the end of the call, when asked for further details about the description, she says the shooters were probably black, I'm guessing. She knew how to say when she was assuming during the call, and she did say when she was assuming. So if the jury heard her say with certainty the shooters were in the call, and then say they're probably black, I'm guessing, they would have had reason to doubt her testimony at trial that she had been assuming. And it was 3 years later. She lived in the building where some people involved in the shooting, the events surrounding the shooting, lived. She had time to be subject to interviews that could have been suggestive, to regret getting involved in this case at all. I think these are all arguments that defense counsel should have been able to make to the jury that would have undermined her testimony that she did not see the shooters. And then I see my time's running out, so I'd like to briefly touch on the Sandoval. First of all, this was certainly preserved. This is a very basic rule of evidence. A basic rule that's existed for 50 years. The weighing is the same in every case. Defense counsel said anything beyond the conviction would not be sufficiently probative. He might not have said the second half of the sentence, which is to overweigh the prejudicial effect, but because that is the analysis in every single case, that was obvious, and the court had that in front of it, so it's certainly preserved. And in this case, it was just extremely prejudicial to bring in those underlying facts. They added very little to his credibility, but took away much from his ability to testify, as he didn't. I see my time is up. Thank you.
Thank you, counsel. Counsel?
Good afternoon. My name is Nancy Fitzpatrick Talcott from the Office of Melinda Katz, the District Attorney of Queens County. The court properly precluded defendant from calling a witness to testify to collateral matters.
Counsel, let's start there. I have some trouble following this collateral witness argument with respect to the girlfriend, because didn't your witness make that evidence critical of why I'm here, opportunity to observe, time and place, and it went directly to contradicting that evidence?
Well, the issue is the time and place of him meeting the defendant and the shooting.
But he made that relevant to me. He made the girlfriend's testimony relevant by saying, I know I was here because X. I took her home, I kissed her goodnight, I turned her around. And why isn't it relevant that she didn't live there, she wasn't with him that night? I mean, it's directly relevant to his testimony.
It's relevant to his testimony, again, on a collateral matter. How he got
To me,
there,
collateral matter would be, I really wasn't dating him. That's collateral matter. But was I there? Was he there with me in the time and place that he's claiming he had the opportunity to observe, or immediately before, which he places really in forefront of his testimony? I don't understand how the argument that that's collateral.
well, had she said, I was with him until 2 a.m., We didn't run into the defendant. That goes directly to his ability. What the material evidence is what he saw running into the defendant and co-defendant, who he knew, and his observations from then on regarding the shooting. What he did minutes before, hours before, the day
Seconds
before.
before, Counselor? Seconds before?
Even seconds, if that was in fact the case, as the defense raised, there was some dispute, he had put it at 11:30, whereas Molina had it at 12:30.
And he's
That-
the sole witness that's giving this damning testimony as to the defendant? It's collateral?
It's collateral what he did before. If she had
But
testimony.
the reason why he was there, his credibility certainly was that which the jury would have to assess as to accept. If he couldn't recall seconds before the incident that he was with his girlfriend, that's relevant on the direct issue of him being a witness, not simply general credibility, the general credibility questions that you ask of witnesses, but directly on the circumstances underlying the event.
But the event would be him running into the defendant and co-defendant and the shooter. So say he was mistaken about the time, and he was tested on the time. He was tested about the lighting. If she had something to say, we went down Beach 15th Street, and it was...
What
pitch-
about him being tested on the fact that he wasn't there for the reason that he said?
Well,
Maybe
but-
he was associated with someone else and would prefer to cast a light as to the defendant being the initiator as opposed to someone he was friendly with.
Well, there's no indication she would have proffered that. It was just, she said, I'm not here before.
No,
If she-
that's the
Right.
point. She would have proffered that the reason he said he was there was not the reason, so it would go into factoring whether or not he was a credible witness as to what he specifically saw there.
Well, if the proffer had been that she could provide some evidence for a motive for him to lie, that's different. Motive to lie and bias are never collateral. That's not what the proffer here was. And the material facts at issue were what he saw when he ran into them and the thing. So now it's up to the trial court.
But let's say we have a hypothetical, counsel. So witness comes in and says, every day at noon, I walk across the street and I buy cigarettes at this same store. That takes me directly across the street in front of this stoop, and as I'm walking there, it's 12 o'clock, the guy pulls out a gun and shoots at these people. And they want to bring in the store owner who says, I've never seen that guy in my life. I work there every day. He never buys cigarettes from me. Yes or no comes in.
I think that's a better case because
Why?
because it's at the time.
So it has to be respect to the time. It can't just be the opportunity that I was walking across the street and passes in front of the stoop.
Well, there's no bright line test. It's really up to the court to decide. So the court here could see, you know what, this is going to lead down a rabbit hole. That they could present evidence. We could, again, as we set forth in our brief, get his Metro card. He said he met her on the A train.
But Ms. Talcott, you keep saying time, and for me, the issue that I keep grappling with is, he said seconds. So we are talking about the same time. So I think your argument on time fails.
Well, he also said it was 11:30, and it's clear it was a little bit later, and he was questioned about that, and they argued that in the summation. So if she had testimony, again, regarding the lighting, did she turn and say, you know, I saw him walking down the block. He didn't run into anyone. I know the defendant and the co-defendant. I was there with him the whole night. We didn't run into anyone.
Can we move to the 911 calls?
Sure.
So I'm having, again, an issue with the people arguing that the present sense impression hearsay exception doesn't apply in this case, where at least we know on Molina's call, she's saying, I just saw someone shot. In fact, I still hear the shooting. The 911 operator is listening to the gunshots, and the people are arguing that that's not a present sense impression.
Well, because it's not corrupt. Well, Molina's call is different than the anonymous calls. She acknowledges the inconsistencies.
But that's for cross-examination, right? That's for
Right. and
impeachment.
That was
We're
all.
talking about the exception to hearsay for the truth of the matter. and she's saying, I'm looking out my window, I just saw someone shot. We can hear the shots on the 911 call. It's corroborated. Police roll up. There's someone with a gunshot wound to his head. What more corroboration is there?
It's not corroborated that the shooters were in the Jeep. Once she says, actually, I'm not so sure, that's not
But Ms. Talca, are
corroborated.
you really arguing that it's not corroborated to the people's version of events, as opposed to it's not generally corroborated?
There's no corroboration that there were 4 people shooting out of the Jeep.
So every aspect of every call needs to be corroborated before it comes in as a present sense impression?
Not every aspect, but the critical inquiry is whether the corroboration offered to support the admission of the statement truly serves to support its substance and content. So the point of precluding it is we need some reliability. So you need reliability as to the substance and content for which it's being admitted. So for the one call and Molina's call, it's that there were 4 shooters in the Jeep. For the third call, it was a description of the person with the rifle. There actually is no corroboration to the substance and content of the calls. We're not saying that every aspect of the call has to be corroborated. But the point that we're questioning the reliability about, that's why it's precluded. You need corroboration for that. The substance and the content for which it's being admitted. And in any event, the court's discretionary rulings were harmless. There was overwhelming evidence, and the precluded
Counsel,
evidence...
did you argue at all that the justification defense was not available under these circumstances?
I don't believe they did it. I know the court charged it. I don't believe we opposed the charge.
So then it's difficult to see how it would be harmless.
The jury was well aware that there was an SUV, that Molina had said there were 4 shooters out of the Jeep. They were fully aware of that evidence. They were charged on the justification defense. Also, Moulton's testimony is strong, and it's largely corroborated by other witnesses and the ballistics. He's the one who has them shooting first and pulling out the weapon and shooting first. But much of his testimony is corroborated by the other evidence. And Johnson's testimony, again, would not have spoken to what he actually saw with respect to the crime. Running into the defendant, how he knew the defendant, and everything that happened after. And he was fully able, the defense was fully able to question his credibility on those direct matters. They questioned him about the lighting, how he knew the defendant and the co-defendant, his description of the guns, and whether his familiarity with the guns, his credibility about Facebook and having friends at the party, his credibility about the fall and the injury and what he had reported to the police and the medical personnel. They even suggested during their summation, he was the shooter. Maybe he was the anonymous caller who called in when they found the murder weapon. They were fully able to put forth their justification defense, and the court properly exercised its discretion in precluding irrelevant or inadmissible evidence.
Thank you, counsel. Counsel, your rebuttal?
Thank you. Just respecting, the people said that motive to lie and bias are never collateral, but it doesn't have to be direct evidence of motive to lie or bias. It can be circumstantial evidence of motive to lie or bias. And I believe in Knight that was true. In that case, defense counsel proffered 2 alibi witnesses, and they said that they had given the same alibi to the police. The police officer was allowed to come in and testify that they had not told him that alibi defense before. That's not direct evidence that the alibi was a lie. It's circumstantial evidence that the alibi was a lie, and that was properly admitted. And then I would just like to address the issue with seconds. It was, of course, Moten's own testimony that he parted from her seconds before. If she wasn't with him at all, how soon before they parted is not important. What is important is that he said seconds before the shooting he was with her. And then, of course, we would argue this is not harmless. There was not overwhelming evidence to disprove Mr. Deverow's justification defense. This was a case with a lot of holes. There was no forensic evidence connecting him. I think crucially, this court should consider that the second department found it was error to admit a revolver that he purportedly possessed. And although that court found it was harmless, with these other errors, it certainly cannot be considered harmless. And altogether, Mr. Deverow did not have a right to present his defense and was deprived of a fair trial. Thank you.
Thank you, counsel.